Hafade, and thank you for your patience, everyone. Welcome to the Guam Congress Building. This is the Committee on Health, Land, Justice, and Culture. It's called to order at 12:44 p.m. Today's Tuesday, September 3rd, 2024. In compliance with the Open Government Law, notice for this public hearing was published in the Guam Daily Post and on the Government of Guam Public Notice Portal on Thursday, July 18 and Wednesday, July 24, 2024. Notice was also sent by email to all senators and all main media broadcasting outlets. This hearing is being live streamed on the Guam Legislature's YouTube channel. There's only one agenda item today. That's Bill number 334-37 LS. It was introduced by myself, Therese M. Terlaje. It's an act to add a new section 75A 126 to Article 1, Chapter 75A, Title 21, Guam Code Annotated, relative to removing legal clouds on the existing leases issued by the CHAMORU Land Trust Commission. I'd like to acknowledge my colleagues who are here with me today, beginning with the Vice Chair of the Committee on Land, Senator Joanne Brown, Senator Jesse Luhan, Senator Chris Barnett, and Senator Sabina Perez, Sidus Masi colleagues, for being here. And I want to thank all of you who've been here waiting patiently while our hearings got delayed this morning due to a continued session. So I thank you for waiting, and we'll proceed. Being the primary sponsor, I will very briefly introduce the bill. Again, the bill was introduced under the recommendation and suggested by the Attorney General of Guam. In his letter, he stated that the goal of the bill is, quote, to solve the problem created years ago with the CLTC leases for CHAMORU Land Trust land that are void due to persons applying for them not doing so pursuant to Guam law, unquote. So I'd like to thank the Attorney General for drafting this proposed legislation and to provide a possible legal framework for the CLTC to operate and finalize some of the long-standing issues it is facing. I just want to provide a very brief context of how we got to this point in these leases. In 2018, the awarding of Barangay Heights public land leases drew negative public attention to the CLTC because the $1-a-year leases in the upscale area were awarded to government officials and certain Department of Land Management employees or their relatives, according to files and media coverage of the incident. The Attorney General at that time opened an investigation into the roughly 103 leases that have been approved and are issued to applicants, and subsequently issued an opinion on May 11, 2018, that, quote, these leases involve individuals who were, 1, original applicants who filed an application for CHAMORU homelands in December 1995, 2, occupied lands prior to the implementation of the Act, 3, those who switched with the 1995 applicant, or 4, those who assumed a 1995 applicant's sequential priority status subject to the date and time of the original application. The opinion concluded that the leases fell into one of the two categories: voidable, with legal remedies for the CLTC to act upon them, or null and void, and not subject to CLTC's power to correct or remedy. Additionally, the AG advised the Commission to review every lease to conform to ethics and government standards. Internal conflicts of interest where identified and proven should be corrected immediately so as to restore public trust and confidence in the integrity of the CHAMORU Land Trust Program and the protection of CHAMORU homelands for all generations, unquote. Since then, steps have been taken by both the CLTC and the Guam Legislature to resolve the legal issues surrounding these leases, though these steps have not fully put the legal clouds surrounding these leases to rest. That's probably an understatement. An extensive review was conducted again by the CLTC and with findings made and documented in resolutions number 2018-8, 2018-9, and resolution 2018-10, adopted October 2, 2018 by the CLTC. 2018-8 notes that there are 4 separate categories created by the CLTC for agriculture and residential leases, including 1995 original applicants with leases, transferred and switched leases, 1996 and after applicants, and 1995 applicants without leases. The resolution went on to identify and ratify 2,877 leases that were 1995 original applicants with leases, transferred leases permitted by Public Law 2338, 1996 and after applicants with leases. Resolution 2018-9 provided recommendations for amendments to the Paul J. Berdalio Rules and Regulations, which they found necessary to update the issuing of leases and avoid hindrance to the process moving forward. These are some of the bills that we have introduced, some passed, some still pending consideration by the body in full. We're also still looking at some of the other proposed language requested by CLTC to see if these proposed solutions are legally sound. So I think the hearing on this bill will also help us in moving forward, if necessary, on any other of those bills. So Resolution 2018-10 requested CLTC authorization to ratify 102 leases that were found to be null and void. Since then, CLTC has been conducting a thorough review of these 102 leases, some which they are able to act on within the boundaries of the law. And I'm hoping to get an updated report on those today. Further, on December 28, 2022, CHAMORU Land Trust adopted Resolution 2022-005 to consider additional authority requested through amending Public Law 2338, the Paul J. Berdalio Rules and Regs. They acknowledged they would like to resolve leases that were awarded contrary to law. After introducing bills to address certain CLTC rules and regulations, I got notice that the CLTC acting administrator testified that he requested a legal opinion from the AG, dated February 14, 2024, noted that, quote, upon closer examination, we, the CLTC, have discovered that many of the ratified leases still contain defects related to the processing of lease applications and the authority granted under the CLTC Act and the GAR, citing 5 examples. The letter did not indicate how many of the 2,877 ratified leases contained defects. So that brings us to this bill, again, introduced by myself at the request or the recommendation of the Attorney General of Guam, and what we hope to be a process outlined in law for the CLTC to remove the legal clouds on existing leases issued by the CHAMORU Land Trust. Attorney General, will you be discussing what the bill does directly? All right, then please, thank you again for your patience. You are invited, you and any of your representatives. And if I could also ask representatives of the CHAMORU Land Trust to also have a seat at the table if they are here and wish to testify. And I know there are others also signed up, so we will get to you as well. All right, Attorney General, you are recognized.
Thank you. Hafede, Madam Speaker, Senator Barnett, Senator Brown, Senator Luhan, and Senator Therese. This testimony is submitted on behalf of the AG's office and our client, the people of Guam, in support of Bill number 334-37, which seeks to remove as many legal clouds as possible regarding the legality of existing CHAMORU Land Trust Commission leases with Guam residents. I trust most of us are aware of many of the legal concerns that exist within the CHAMORU Land Trust's existing portfolio of leases. Some of those leases were signed by former agency directors without prior approval of the Commission. We understand that, for the most part, those legal issues were resolved by subsequent Commission action ratifying the lease. The bill we consider today addresses more legally problematic leases. Those are leases issued to persons who improperly jumped the line and leases issued to persons who improperly switched their lease priority with someone else. As former Attorney General Elizabeth Barrett Anderson opined in 2018, where there is no legal authority for the Commission to grant a lease, then the lease is null and void and cannot be fixed by administrative action. Neither current law nor existing regulation permit jumping the line or switching the lease type on what is applied for. That is why we are here today. That is the history that we have to work through. We should make clear that the bill seeks to change we should make clear that this bill seeks to change history, not something we typically do with legislation, but history is the problem that has stalled the CLTC from making forward progress, issuing new leases to Guam residents. Where a CLTC tenant is today occupying land subject to a lease that is regarded as null and void, the typical legal remedy is to require the tenant to vacate the property. According to the Commission staff, the total number of these null and void leases is approximately 2,800 out of the total lease population of about 2,900. In that entire population, there are only 19 leases where CLTC staff have concluded that there are 0 legal clouds. Let me acknowledge that the CLTC has done an excellent job of reviewing and analyzing their existing portfolio of leases, and they know where the problems are. No one really wants to remove a tenant from their CLTC land if the tenant is otherwise in full compliance with the terms of their lease. This requires either court action or a legislative remedy. Events such as typhoons or a tenant's desire to improve their property with borrowed money bring this legal conundrum to the forefront. Whether a tenant wants to borrow money from FEMA, the SBA, Guam Housing, or a bank, they need to ask the CLTC for their permission. The act of borrowing the money will create a lien on the CLTC's property that the CLTC has a right to consent to the claims of others on their land. Now, when a tenant with a problematic lease comes in and asks to borrow money for a typhoon repair and wants CLTC approval, the Commission is in a difficult place. If they approve the tenant borrowing the money, they are putting the tenant in the difficult position of having to pay off a loan on a house that they may not have a legal claim to. But because no one really wants to tell a good tenant to pack up and go, the Commission has tended to do nothing, pending the opportunity such as we have here today to fix these problems. So let's be clear that while the legislation attempts to change history, we aren't exploring why we find ourselves in this position we're in. The bill simply authorizes the CLTC to enter into a brand new lease with an existing tenant under 2 scenarios. The first scenario is where the tenant is otherwise in full compliance with their lease. They've constructed the house where they are supposed to. They are paying their taxes. The only legal concerns with these tenants are that they or an earlier relative jumped the line or swapped places in line with someone else with higher priority. This legislation directs and authorizes the CLTC to enter into a brand new lease with the tenant for a term that matches the remaining term of their problematic lease. The new lease resolves any existing problems, and the tenant can move forward with developing their property free of any legal cloud. The second group of tenants that the bill addresses are those who have null and void lease issues, but who have other problems as well. For example, the tenant has not paid their property taxes, or if it's an agricultural lease, that they aren't in full compliance with requirements for CLTC farms. The bill requires the CLTC to issue these tenants a notice of noncompliance, and they have 1 year to come up into compliance. When they do so, the Commission will enter into a new lease, legally sound. We also think it's important to set deadlines for this effort. So the bill asks the CLTC to complete the work of cleaning up the lease for persons who are in full compliance today by December 31, 2027. For leases that have other problems, the cleanup is to be completed by December 31, 2029. In recommending these dates, we consulted with CLTC staff. We are not married to these dates, but we do think it's important that there be a deadline certain for this cleanup effort. And to be clear, the bill directs the Commission to seek to terminate any leases for persons with multiple problems regarding their lease who have not remedied those problems by December 31, 2029. No one wants to tell a lessee to vacate what they regard as their home, but when the legislature created the trust, it created expectations for those who were getting essentially free land. We think it's important to move off people who won't meet the legislature's and our people's expectations, and to give the opportunity to another potential tenant to put the land to more productive use. In another moment of clarity, we must acknowledge that some of the persons who hold a CLTC lease but have yet to move forward with the construction of a new home haven't done so because of the lack of utilities to the property. That is a very real problem, but a problem for another day and another bill. When the legislature created the CHAMORU Land Trust, they didn't guarantee anyone utilities to their property. That reality highlights a lesson learned from the trust being in business for about 30 years now. When a tenant is awarded a lease, we should understand that what they've been awarded is opportunity to start up a construction project, borrowing money, hiring architects and engineers, supervising contractors, as you know, is a lot of work. As the legislature continues to monitor and oversee the work of the CLTC, perhaps future legislation might address how to minimize the obligations of a tenant to become a construction manager so as to assist their award of the lease, or to create a self-funding trust to assist with major infrastructure projects. As a final note, this testimony does not address other matters facing the CLTC enabling laws, such as any equal protection or other legal issues. Senators, as a final note too, comments were made about certain leases clearly maybe violating the a corruption type activity where certain managers or their families have received property, such as the Barragata Heights situation, things like that. This, I don't think, addresses that specifically, but in any modifications to the bill, the senators could put a discretion within the CLTC or not allow those type of leases to be under this program. I do note that there's a long history of potential other abuses of this situation. Thank you.
Cesar Masi, Attorney General Moylan. And I know we have with us Assistant Attorney General Lee Miller for my colleagues. And would you be testifying as well?
Nothing further to add at the moment. Happy to take any questions.
All right, Cesar Masi. He is the attorney assigned to the Chamorro Land Trust at this time. That's correct?
Correct.
All right, thank you.
That's correct.
Thank you. And we also have with us the Acting Director of the Chamorro Land Trust Commission, Mr. Joey Cruz. Would you like to testify?
Good afternoon, Speaker Terlaje, Senator Barnett, Senator Brown, Senator Luhan, and Senator Therese. At this time, CLTC will not be providing any written or oral testimony. Our CLTC board has not had the chance to discuss the bill collectively, although it will be discussed in our September 19 board meeting. Thank you.
All right. Maybe I'm going to start with a question then from, oh, I'm sorry. Let me just check. Is there anyone else who would like to present testimony on this bill? All right. We've got Peter Santos. All right. Attorney General, are you able to stay and answer questions, or Attorney Miller?
I can stay.
All right.
Speaker.
So, Susa Manabusan? Joseph and Susa Manabusan? If I call your name and you don't wish to testify, that's okay. There's other CLTC employees here who signed in support, one who signed in not in support. The chairperson of the CLTC was here, Ms. Arlene Berdalio, but doesn't indicate that she would be providing testimony. Josephine Garrido, I thought, Ronald Laguatnia, Carlos Camacho. Oh, there you are. Would you be providing testimony? Okay. Is there anyone else then? Okay. What's your name, ma'am? Oh, Lydia? Oh, okay. All right then. Yeah. You we'll hear from Peter Santos first, and then you. All right. Lydia. Mr. Santos.
Good afternoon,
Attorney Santos.
Madam Speaker and other senators, esteemed senators on the committee. I'm here today to testify in support of the bill in my personal capacity. As a member of our society here on Guam, born and raised, I've watched what has been going on with the CTLC from its inception to how it is today. And of course, Speaker, you did talk about how we arrived at this situation, and I also have an opinion on that. I've spoken with a lot of former commission members, current commission members, and I've always asked them, you know, how was your legal support? And they said things like, sometimes the lawyer never showed up, sometimes he showed up, but It was always a different lawyer. And these are from all the past administrations, right? It's always a different lawyer. We ask them questions. They never get back to us. And so that's why we got to this situation, because there was no strong guidance. I believe in preventative law, and if they had a lawyer that was engaged and interested and had the courage to hold them accountable, then we wouldn't be here. But that being said, we are here. I read through the bill. I like the intent. It does say that the commission shall meet with an eligible beneficiary. So there's going to be, from the get-go, some people that are not going to be covered by this, because there are some people who are occupying lands that are not eligible. I mean, just one notable one is the omelet farm, right? They're occupying that, but the person that's occupying it is actually technically not eligible for the program. So there needs to be another way to try to remedy that, like maybe work with them and find a family member that is eligible that can take over the lease, right? Right now, that's not something I believe the commission can do or is doing, but that's something that can be done if they craft legislation to do that. So that's one thing. And then the other thing is, in my experience in the military, we had to do what's called reports of survey, or some type of investigation into something that didn't go correct. And the appropriate level of authority has the plenary authority, like the legislature does, to ratify things that weren't in compliance previously. That's not uncommon. But one of the things that we had to do was document the report, the investigation. And I think there should be for every lease, there should be a documentation, a report of findings on what, and I suggest also that they direct the commission to make a determination whether there was good faith, bad faith, and detrimental reliance. So if there's good faith, as in the leasee relied, or not relied, but dealt with the commission and felt like they were doing everything up above board, and then they used that and turn around and made improvements or built a house, and they relied on that agreement, which in their hearts was a good faith agreement, then those should be ratified. If they make a finding of bad faith, then those should not be ratified. I mean, it's a moral imperative that people should not be rewarded for their illegal acts or bad behavior. And then there's a situation where maybe the original lessee was the one that did the bad faith, but then now it's being occupied by an heir. So in that case, you can make an exception, like, okay, so the heir didn't have anything to do with it, so go ahead and ratify it. But, so I don't think that anyone who is found to have committed bad faith should have their lease ratified. And then the last thing is the severability clause. As it's written, it might just render the whole thing void. It should say, is found to be contrary to the Constitution or the Organic Act. Because if it says contrary to law, there are laws on Guam that this thing would conflict with. Thank you.
Jesus Masi. All right, thank you. Mr. Lu. Oh, can you turn on that mic? Yeah. Jesus Masi.
Hello, my name is Lydia Talil. Why I am an employee of CLTC, I am not representing CLTC. My opinions I give today are that of my own. Normally, I would have submitted a written testimony. As the speaker knows, because generally she probably gets them the night before, I send them off because I work diligently on my testimony. This one, I had to come in because I have very strong opinions in regards to this bill. I do recommend the Attorney General for the amount of thought that he put into this bill. And while I agree on certain areas, in certain areas I do not agree with. Legal clouds, what a delightful way of describing illegal acts that were committed by past administrative directors, DLM, and CLTC employees. Leases that are considered null and void are based on practices that are directly contrary to the act. CLTC cannot use the excuse that they had no rules and regulations. On my very first day at CLTC, February 29, 2016, when I came in, Eileen Chargalov, and Land Agent 2, walked up to me because I was covering the front and handed me Public Law 2338, the rules and regulations that involve CLTC. I was told, read this, study it, and know it, because how we work in this agency is based on the rules in this act, which I did do. When there are things that were brought up, I brought it up to the land administrator at the time, questioning it as to why we were doing things that were contrary to the act. And I was told, well, that's how we've always done it. So close to 30 years of us, that's how we've done it, has gotten us to this point. And we are gonna just blow it away. And I'm gonna give you examples of things that were done by CLTC DLM employees. We have one DLM employee whose father-in-law did not qualify for the lease. So what they did was, rather than terminate the lease and have somebody in the family come in and apply, they simply transferred the lease, knowing that the original lessee did not qualify. And that was a practice that was done with many other lessees who are now coming forward, who are requesting for assistance in getting an SBA loan, but because how that original lease was issued, they are now stuck because they were given bad advice by CLTC. Now, it wasn't the lessee who has no connection to CLTC other than being a lease, she is not at fault. But the employee who was, do not tell me there was no colluding going on, because this was done under when CLTC was part of DLM. We have another employee of DLM who he got his lease from his mother, but his mother wasn't married to a DLM employee, and they were both issued a lease. GCA 75A and 75, 108 both state a married couple cannot both have a lease. They either give it up or they transfer it. But what did they do? They allowed him to transfer the lease. They didn't terminate the original lease. They gave him a new lease at Barragata Heights. So now you have one application, two leases, two different effective date with two different lot descriptions for somebody who never should have been issued a lease. We have another employee, priority 2, residential. As we all know, residentials, you only process priority 1s. Once all the priority 1s are processed, then we can work on priority 2. She was a priority 2. They all knew it. She sat in the break room, talked about building her house, what fixtures she was gonna build. When it came out, they're like, oh, okay, we're gonna fix it. We're gonna go to the board and we're gonna request the board to transfer it. It was within the 7 years, and it was never disclosed to the board that what her priority was. The reason she made it sound like she was a brand new property owner, when in fact, prior to her being issued a lease, she was given the property. Prior to her being issued the lease, she signed a loan agreement with Guam Housing. A month before her lease was signed, she got a completion, she can occupy her property, all while acting as a CLTC land agent. And there's no colluding? I understand for those lessees who simply follow the rules and regulations, other than them being issued a lease out of date and time, hey, because at one point they had the thinking was, as long as you were December 1995, we will process you. I could go along with that, even though that's not, it's technically out of date and time. But those who blatantly broke the rules because of their connection to CLTC, no. If you're going to pass the rules, then make it where only those whose date and time is out of line. Because the sheer numbers of people who are waiting to be issued a lease is staggering, and we are still accepting applications. And when we tell them, oh, you gotta wait for your date and time, well, what day are you at? We're on December 2nd, 1995, and we're up to 8:17 in the morning. The thousands of people that have waited patiently, that have been following the rules, now have to qualify under a new set of rules, and they can't get a lease because their date and time is not up. But people who illegally jumped and got their lease that was contrary to the act, that was blatant about it, they get to get a new lease? Sorry, no. It is not fair for all the others who had paid their $50. And back in 1995, $50 was a lot of money. We might go, oh, big deal, $50 now. Might not be a big deal now, but $50 back in the day, what I could do with $50 back in the day. Fill my gas tank, go to Denny's, be at the club all night, having a good time with $50. And that's because I was single. I don't even want to imagine what a family had to do, what they had to give up $50 for back in 1995. And yet they still have to wait? They have to qualify under the new rules because CLTC didn't follow the rules and regulations despite it being given to them? Because that's how it's done. Stop the madness. Now all we have to do is follow the rules and regulations. Those who were issued a lease and had done everything correctly that qualified, other than being issued a lease out of date and time, if they were the original applicant, by all means, allow them to renew. But for those who weren't, who were issued leases that were blatantly incorrect, no, it is not fair. Thank you. Oh, just on a personal note, I'd just like to thank Speaker Terlaje, Senator Joanne Brown, and Senator Chris Barnett. A couple years ago, there was a staff report that I had submitted that was incorrectly represented at a board meeting, and I had brought it up. You were the only three that publicly stood up for me. And I want to take this time to thank you, because the words that you said on your radio show in subsequent interviews meant a lot, and it gave me the reason why I continue to work.
Sijus Masi, Ms. Hello, for your work at the Commission and for your testimony today. Thank you very much. Is there anyone else who'd like to testify? Mr. Camacho, would you like to testify? No? All right. All right. Questions for the panel. Let me start with Attorney Santos's recommendation for finding of bad faith, that those be disqualified. Do you think that such a category would be able to be determined? This is to Attorney Miller or the Attorney General. Yeah, do you think if we made such a category, good faith, bad faith, and we don't ratify the bad faith ones, that we would be able to implement that?
Madam Speaker, as you pointed out, this is a long history since 1995, and there's been coverages of what appears to be fraud that has occurred here. The criminal prosecution is capped at the 3 years for the most part for certain types of crimes. But I mean, I agree with the speaker, Lydia, is it Tilu? She speaks like a honest person that is trying to clean the system up, which and I appreciate her recognizing that this Attorney General's office is trying to get the system moving again so people can actually enjoy these properties in their lifetimes. I agree that, and I was speaking with my acting deputy here, that there should be a provision built in to give the CLTC the ability to root out those fraudulent cases that Ms. Chalou has indicated. I think that that is a good amendment to the bill that the senators may wish, the committee may wish to incorporate to, because the bill is designed as a prophylactic in order to deal with two categories that I understood: people jumping to the front of the line that shouldn't have been there, that have built their homes for at least 20, 30 years, something like that, and then those people that basically are in breach of the contract, which are kind of innocuous. But when you have allegations that I've just heard right now, that people have had family members that had never earlier applied, jumping in, or whatever you would consider a fraud, that should have a process for the commission, the Chamorro Land Trust Commission, to take a look at and to not grant it. I disagree with Attorney Santos in the respect that this isn't a ratification. As General Barrett Anderson opined in 2018, these leases are void. You cannot save them. The only way that you're going to do that is to offer them a new lease. So you can't take something that was bad initially and then offer them a new lease. That's why Lydia's comment to jump in before you give them a new lease seems very appropriate through some sort of mechanism, but then we got due process rights that kick in. May or may not be due process. It's this idea that these people are on the property right now. They've, the legitimate ones, I guess, in this whole spectrum that we're talking about. What do you do with those quasi people that should remain there out of equity versus those that got there out of bad faith and fraud? And who's going to determine that? And then what processes are entitled to? Because what you would do is you would literally not give them a new lease, get off the property, have the lawyers come in and evict them, and then put the next person in line back in 1995 to be the next applicant for that. In my mind, that's justice, and that's where this bill could be improved.
Right, so the mechanism of we're going to sort and we're going to determine whether your violation is just jumping the line somehow, or whether there are other issues and you have to resolve those. I'm all for that. But so we have one suggestion that says sort also for bad faith jumping the line.
Right.
Let's
the
say,
two are the
and
same.
or employees of the CLTC jumping the line. And you're introducing the term fraud.
Right.
Those are all three different categories for me. I want to know which one can we actually implement, if any, because it seems to me the commissioners would have to make a determination of their intent, and these are talking years back, some of these. This is a problem for me.
It is the problem. So you're either going to pass the prophylactic like we've introduced it, which arose from our office's communication with the current Chamorro Land Trust Commission to get the system moving, or you're going to try to make it move forward but have some sort of a dispute that in a certain amount of time, arguably, you craft a piece of legislation that says that all these leases shall be renewed provided that these things are met by the Chamorro Land Trust Commission. It's kind of like there's a different spectrums that you can incorporate into this, and both the previous speakers are correct. It would be tagging it before you issue them a new lease.
Right.
And I think that there's a lot of discretion because you guys set the rules. As long as there's not an equal protection type of violation that you're treating people differently necessarily.
What if we, okay, so let me ask it in another way. If we put in the language regarding bad faith, and we defined bad faith to mean you were an employee and you did this knowing the rule,
Conflict of interest.
We don't even have to say that you knew the rules. You were an employee, so we're going to presume
Right.
that you should have known the rules, or some other person, and I'm trying to look at different examples, but let's say we define bad faith. Do you think that's something that commissioners can implement, a bad faith determination?
I think they can. I think the commissioners have a certain amount of latitude on allowing their lease to be issued another lease. Because right now you're already setting aside those people that should have gotten that had the system been followed. So we got past that point and just basically said, for equity reasons, you can keep these people, you can offer them first the new lease, which is the property they're on right now. So you'd be creating another requirement before that new lease is offered to them, which would be a bad faith type of fact pattern. But then who's going to raise the bad faith?
Yeah.
So it would be an idea that you might have a complainant, that you have the list, and if it's internal, that the CLTC is aware of, they would raise it themselves. You would probably have the ability for somebody to, within a certain amount of time, make a complaint against an individual, come forward and, be known and make a statement against an individual that got it, and then the commission would decide that. It's not as easy as what we had proposed, but
Yeah.
it does have the equity involved.
All right. Yeah, so the way I would think about this, I like the term that you use, Ms. Attorney Santos, that detrimental reliance. There are some cases that were just completely approved on, and then relied upon. But I feel like we have this choice now because so many years have passed. So many of these people on the original list are older or have passed this on to some other heir. So even their actions, it's hard to determine who did what. However, we do have people actively, they either got lease or they're living on the property or they had a lease, void lease now. But I feel like we're being asked to, for the benefit of the majority, close your eyes to the few who may have done those things, and that would be the most expedient way. If we start making any exceptions, we're going to take a little more time, and that's we have to think about that.
But,
Yeah.
Madam Speaker, what
Yes.
you just said there could also be a litmus test that the senators could use, that nobody that had a relationship to a CHAMORU Land Trust Commission director, employee of the commission, they shall not be offered new leases. That would be a quick and easy way of saying who's going to get the new leases. So I see a clarity of thought with that type of approach. Just make it nobody.
Mr. Lu, do you believe that would be fair to make qualification unless, you can avail of this law unless you were you were related to an employee of CLTC or land management?
I can only speak for myself personally, and I can tell you 99.99% of the applicants and the lessees I am not related to. I am not of Chamorro descent. Therefore, I do not qualify for the act, nor am I related to anybody who has a lease. But I do have relatives who are illegally occupying CLTC property, and I have all told them, do not show up at my office asking me to give you authorization to apply for water and power, because that's not going to happen.
My question is, and the examples that you suggested, I know you didn't tell us all of them. If we used a category and we tried to categorize them as relatives of employees of the CLTC, do you think that's fair?
That is fair. We actually do have a form within CLTC. When the Barragata Heights debacle, as I lovingly call it, was created, there was a form that came out, and it's the continuity of third-degree form, in which you need to put down if there is a conflict of interest that you have with an applicant or a lessee. I personally have filled out that form because there is somebody who is one of my good friends, but I put down that there is a conflict of interest because while we are not blood related, that is somebody that I'm very close to, and I do not want the appearance of impropriety to be brought up.
So what happens if you fill out that form?
I fill out that form, I submit it to we now have a...
Somebody else handles the case, not you?
Somebody higher up.
All right.
And then I tell them, I'm removing myself from this
Okay.
case, and they are to assign that to somebody else, and I have no connection to that case. I'm not to work on it, I'm not to divulge any information on it, I am not to help that person at all.
All right. When it says the lease was issued in a manner contrary to the regulations of the commission, does this this refers to more than just out of order, right? And it's pretty much anything? Size, date, they didn't build their house on time, they didn't qualify to get a loan, I don't know what.
Madam Speaker, members, you know, my experience with the commission has taught me that there's a story behind every single one of these leases. And whereas the commission's rules and regulations try to be simple, straightforward, and uncomplicated. That particular sentence is by and large trying to capture people either who got their lease contrary to the first come, first serve requirement of regulation, or people who switched between agriculture and residential where there's no statutory or regulatory authorization to switch between those two kinds of leases.
Thank you. Attorney Santos, were you trying to say something?
Yes, Madam Speaker. So with regard to the categorization, and so if someone is going to be proven bad faith, then it's the commission's burden to prove that. And vast majority, they probably won't be able to meet that burden because all the information is old and stale. But it's still their burden to meet that. And the way it can be handled, like I've seen in the past, in some cases, you appoint a special master just for these cases, right? Or like Phil Tidinko recently was appointed a hearing officer to deal with the unemployment claims that were not fraudulent, but they didn't qualify, but they got it anyways. And so he dealt with like 5,000 cases, something like that, something similar. So you can appoint a special master or a hearing officer to handle all this. You've got, what, 5 years to do this?
What was that example for? Claims for what?
The unemployment assistance,
Okay. Oh, yeah.
the COVID unemployment.
All right. Thank you. So there are, for example, on agriculture leases, the requirement to cultivate, occupy within 12 months. Would this fall under this section?
Yes, ma'am.
Okay. How would lessees that are not occupying the property due to lack of roads or infrastructure be impacted by this bill?
As the Attorney General referenced in his testimony, when the CHAMORU Land Trust law was created, the law doesn't make any promises as to what kind of infrastructure will be accessible from your particular property.
All right, so we can give them a new lease, same property.
Give them a new lease, same property, but in the absence of any other change, there still is the expectation that if you want to maintain that lease, you will
Comply.
You will comply with the expectations of the legislature and you know, start to use the property as your home or as your farm.
And Madam Speaker, we had a discussion on that. That may be in the breach of contract category, that they may have been properly awarded the lease but didn't perform thereafter. So, you know, that's the filtering.
Is that a same category then as what we're talking about, or something totally different? Is that belong to the contrary to the regulations, issued a lease in the manner contrary to the regulations of the commission? Does it fit, or are you saying this is a whole other category that shouldn't be considered?
The two, Madam Speaker, members, the two broad categories of clouds, defects, call them what you will, the bill tries to address are people who jumped the line, people who got a lease other than by being sequentially the next person who should have been offered a lease, and The universe of people who applied is for an agricultural lease but wound up with a residential lease or vice versa. Now, there are, within the category of people who were obtained an agricultural lease one way or the other, who did not yet meet the particular requirements, and there are some very specific requirements, as you indicated, as to, you know, your day-to-day, month-to-month, year-to-year obligations to use the property and farm it. And sometimes there are people with an agricultural lease who they're living there, and they have they're growing some crops. Some people might call it a personal garden. Other people might call it crops.
And what are you saying about those?
If you have, what the bill says is if you have an agricultural lease and you're not meeting the very clear requirements to essentially farm the property, you've got a year to farm the property.
You get a notice to remediate. All right, so for all of the ones I'm describing, you get a notice to remediate. For example, if you're supposed to have started farming, there's no water, you get a 1-year notice to remediate, regardless of whether there's utilities in the area, right? That's up to them. Okay,
Yes.
I see. And the acting administrative director, when he wrote the letter to the Attorney General's office asking for an opinion, you know, what do we do with these leases who are not in compliance? Does this bill take care of all of those scenarios that he suggested? There were 4 of them. Do you remember?
Madam Speaker, members, yes, that is the intent.
Okay.
The opinion of the Attorney General's office hasn't changed since General Barrett Anderson's opinion, that there is a, you know, there are a large category of leases that are null and void, and we have to do something with that universe.
And Madam Speaker, may I comment? You know, again, this Barragata Heights travesty that was going on, it's kind of bizarre and extreme, that value up there in the properties, as you were pointing out. You can even just eliminate them. Just say, except for the Barragata Heights property, which shall be all voided, period. You go back to 1995, and you let the next person start applying for that property.
Okay.
Can I make a comment? Not all the null and void leases were centered on Barragata Heights.
Right, that's why he's saying we could carve those out and not deal with those while we go forward with the
But what
others.
I'm saying
You're-
is,
the ones that you're
leases
concerned about were
yes,
not all
they're
Barragata
not
Heights
all
either.
Barragata
Yes,
Heights.
I understand.
They're in other areas.
Yes, I understand. Okay. So, this process to remedy or remediate, is there any other process like this that you know about? Is there any potential legal challenge after they remediate and the leases are issued? Can we close these books? Of course, subsequent to the lease, the new lease, they have to comply to their new lease, right? And we have an enforcement team able to enforce that.
Yes, Madam Chairman. I mean, especially in the universe of the agricultural leases, your compliance requirements are ongoing for the entire term of the lease.
Is, do we need rules and regs for this or not? The bill's good, we just go with it?
Madam Chair, members, I think the Commission's done an excellent job of articulating what the minimum requirements are to be a farmer on a Chamorro Land Trust property.
All right, I know, Acting Director, that you don't have a formal testimony. It hasn't been condoned by the commissioners, but just in implementing it, since you're the one implementing it, do you see any issues in doing what they say, going through these and sorting them in this way, making a determination and then executing a new lease?
Without considering what the board may say or any amendments to the bill, it's achievable.
All right. Can you confirm my numbers? 2,877 ratified leases. We're still concerning the ratified leases?
That number was based on the resolution that was submitted during the previous director, Mr. Michael Bora's time. As of today, CLTC has awarded 2,911 leases. I believe all 2,911 have been ratified.
Yeah, and do the ratified leases, are they done, or do they need to go through this process as well?
Only 19 out of the 2,911 meets the priority status of the first come, first serve.
Because those were the ratified leases were not even in the null and void category. Those were in the voidable category, right? And they were ratified. So do you agree that those ratified leases have to go through this process, or can we just leave them as is?
Madam Speaker, members, the ratified leases, to my understanding, before my time here on Guam, largely dealt with leases that were granted, signed by the executive director of the Land Trust Commission prior to a formal award of that lease by commission action. Because the commission subsequently awarded the leases, the fact that the director signed first, which is not how it's supposed to go, that solved the problem of the director signing first, commission voting second. But even within that universe of leases, we still have the problem of people who jumped the line or people who swapped priorities. So yes, we do have to evaluate the ratified leases as well.
Okay, all right. So the 102 null and voids and the 2,911 minus, what did you say, 14?
19.
19, okay. Are there any other lease scenarios that are active that you think may not be remedied by this bill? Anyone?
Madam Speaker, none that I'm aware of.
Okay.
None.
Okay. All right. Thank you. All right. I'm going to ask my vice chair if she has any questions or comments.
Thank you, Madam Chair and Speaker, and thank you to all of you for being here to provide testimony on this bill. And also to you, Ms. Talou, for taking the time to, stay consistent and speak out about what has happened in the unfortunate history of the CHAMORU Land Trust. And, we've been aware of the abuse that has occurred there from people that have been in position of leadership, and also the employees, some of the employees over the years that have taken advantage of their position to benefit themselves and members of their family. I mean, we're not just talking about Barragata Heights, we're talking about oceanfront property. And that abuse has happened, and we've also had situations where family members, siblings, have been able to get leases adjacent to existing land that they own. And you have to wonder, how does that happen? It shouldn't happen, right? If they were going through the process and first come, first serve, and a list of properties that were available so that matched those that were applying and in the sequence that they were applying. And we've seen time and time again how political interest has interfered in this process, and people that weren't even in line or at the front of the line ended up having lots provided to them. We have situations of course, where land has been received and not being used for its intended purpose. It might be used for residential purposes, but not by the individuals that have leased the property. It might have been taken for agricultural purposes, but not used at all for agricultural use. Some of these lands have been idle. There's been no work done on them whatsoever, but it was an intent to essentially grab the land, have the land, hold on to the land, and have it under their name. So this is going to be quite an undertaking in going back and trying to undo, or at least try to put in some sense of order, a lot of the misuse and abuse and downright, in some cases, illegal actions that have occurred by the land trust, and be it the previous executive director, directors, whatever the case may be, or the commission by their own actions, sometimes not really knowing beyond probably the information provided to them, are unaware of how this land has been misused. We've had commercial lots that have been subleased out without the approval of the commission, which the law requires that if you're going to sublease commercial land, you have to go back to the commission and get authorization. And then you're also required to provide a certain percentage of that income that you receive from these subleases to the commission. Number of cases that has not been followed, number of cases, collection of these lease agreements have not remained consistent, and we find some, like the golf course, have been at the top of the list for many years because there's not been consistency on following up and ensuring that the money owed to the commission is paid. We've had situations where businesses have come forth and leased commercial property, and then for whatever reason, because they're not able to start construction, come back and ask the commission for deference of their lease payments until such a time they're able to build or receive revenue from that and hold on to the land and keep it under their name when they have not fulfilled the obligation of the lease. Because it really should not be the burden of the Chamorro Land Trust to sit and have them hold on to the land if they've not taken appropriate action to develop on it. That should be irrelevant to the money they're supposed to pay for the land trust. So yes, the lease is long. I mean, I'm hopeful that this legislation can help provide some sense of direction to put this whole process in order, because it's really a shame that the intent to provide land to those that are eligible for very basic use, for a home, for agricultural purposes, for subsistence, for themselves, or should they choose to sell other agricultural produce, again, it allows them additional income. But the degree to which we have seen the misuse, I mean, if we're talking this number out of 2,911 leases, a substantial amount that really were not and did not follow the proper process, you got to wonder, what were people doing? It's really a very sad day to realize the degree and the magnitude of the abuse in the commission. This is substantial. This is not even a few here or there under the table. This is almost saying 90+% of the leases that were awarded may not have gone through the proper process. And that is just, I don't even know the word. Is there a word in the English language that we can use to describe this? I'm sure that was not the intent of the forefathers, shall we say, who, you know, like Paul Bradalio, who authored the Chamorro Land Trust, or Angel Santos, who fought for the implementation of the land trust. I don't think any one of them would look back and say, this is what we intended and this is what we hope for. What does this say about us? What does this say about us as a government? Not good. Not anything that I can say is good. So, Attorney General, how would you deal, or how would you recommend, even in the review of these leases, if the land trust goes back and determines there's been misuse of that land? Not just that maybe it wasn't properly given to an individual or a company, but if it's determined in the review of that there has been misuse or abuse or outright illegal activity that was not intended by the lease agreement, what can happen there? Is that a lease that the land trust can void, or simply not move forward through this process to legitimize it? Because that's a concern I certainly have. I'm sure many others that have been standing in line since 1995 would like to see properly addressed and resolved.
Well, based upon was it General Barrett Anderson's opinion, which I agree with, they're void already. So the eviction of them should not be a problem, to just remove people that are on the properties. All 2,800 some that we have here, 877, they do not have an enforceable lease. They should and can be evicted regardless of the equities. What you're saying right now, Senator Brown, makes me think. If you created categories of certain areas that are automatic, that will not be considered for offering a lease, Barragata Heights, oceanfront property, whatever the case is, but even those lots that nobody's on it, if you've got pieces of property that were just basically kept in place and haven't been developed at all, don't even entertain a time frame for them to come and make it good for the residential. You've lost it, it automatically will remain void, and a new lease goes back to the 1995 placeholder. So, you know, this is why the committee hearing is so important, for the equity of the senators to come in and decide, no, we're not even going to tolerate that. We were not even going to talk about bad faith. We're just going to say that these categories, you shall not have that right anymore. I think the Barragata Heights was the most recent one of potential abuse that was going on. So the their reliance on that land probably isn't very much. And it would be questionable whether or not they even got a loan on it that was using the property, or the Chamorro Land Trust issuing any security for that. So when you talk about the corruption and the amount of potential corruption that we're talking about here, you start with the idea there is not an enforceable lease. You have no rights to the property. So who you're going to offer to get their new lease is up to you as senators. But the fact that we're actually having a bill with a number on it now to try to bring closure to this, this part of our history, I think is important, that we trigger a new mandate for the commission on how it's to go forward. And, you know, quite frankly, have the Attorney General's office be, one of the signatures requires the Attorney General's office to look over each one of the new leases, something of that nature.
If I can ask the acting director, are you prepared to, or have you provided the assessment on each of these properties, or are you prepared to do so before you bring them before the commission to legitimize these leases?
What we've done so far was take the ratified lease listing, and we're going to go through them individually. There's several categories that some may be a part of, maybe one, maybe all three or four, but we're going through them now. Next week, we'll be publishing an ad in the newspaper for the applicants and the lessees to update their contact information. So we're preparing, and we will vet them individually to ensure that it complies with any bills that become law.
Are you going to be doing physical inspections of each of these properties?
We will be, in order to determine whether they're in compliance with their lease terms.
Have you notified previously with the previous leases that have been nullified? Have these lessees, have they been notified in writing that their leases are no longer valid? Are they aware of it in formal notice by the Chamorro Land Trust Commission?
I don't recall, ma'am. I don't believe so.
So you have no records of notifying, because this is a substantial amount. If out of 2,911, there's up to a possibility of 2,800 that are not in compliance.
If there was
and that pretty much covers probably 90+% of those right now that have a residential or agricultural lease. The Land Trust has never notified them that they might not have a legal lease?
If there was any notification, it was to the initial 102 that was deemed null and void by the former Attorney General, Elizabeth Barrett
So
Anderson.
how did we go from 102 to 2,800?
When we went back and we reviewed the ratified lease listing, like Attorney Miller had mentioned, it was just because of the award by the administrative director that was ratified. We went considering the opinion that stated without any further defects. I don't believe that was considered when the ratification process was done. So the initial task of a lease award is an applicant's date and time. So that violated that part of our rules and regs. So that's how the number grew. And then aside from that, the switching of application type, the law is silent on that. So we took the concept of the switch of application date and times amongst applicants and applied it the same way. The law was also silent. So that deemed those leases null and void.
Are you prepared to do enforcement in the event that it's determined or action is taken by the commission that it will not allow a lease to be confirmed, so to speak, and not move forward as a result of your inspection if you determine there's been misuse? I'm not talking about building a house and, you know, planting your coconut trees or whatever the case may be, because I think planting a bunch of coconut trees can meet the requirements of an agricultural lease, but are you prepared to do enforcement?
If the law requires it and the board decides that a lease may not be reissued and enforcement, for example, eviction, then yes, we are.
And you're prepared to do so? How are you going to address that? What are you going to do to address eviction?
We will ensure that we work with our attorney to ensure that the proper notification and timeline is given for the applicant or the individual that's there to move out.
Well, you have a substantial job ahead of you because, I mean, we realize that there are a lot of issues with the land trust, but not to the magnitude that we could have out of 2,911 leases, 2,800 questionable. That's, I don't even know what to say about that. That is, it's a failure of the proper implementation, and yet, you know, there's a lot of people out there that I know legitimately may have, or maybe improperly because it's the executive director that signed off on whatever, you know, who are properly using their land for their residential home or for agricultural purposes. But we know there's a lot of cases that that is not the case, and it's been the weakness of the commission following through with the original intent of the law, implementing, and also very much so enforcement. It's a very significant area that the land trust historically has been very weak. And as a result, we've seen and continue to see consistent abuse and misuse of the land trust land. I think many of us, and I've never applied for land trust land, even though I'm eligible. I think there are many people who have stood in line who still up to this day come back and say, you know, here we are since 1995 and never received our lease, only to find out there's many that got ahead of them for whatever connection, relation, whatever the case may be, that are still waiting, that really want to see justice, because the time that they have lost is time that they never, ever will get back. So it's going to be quite an undertaking. I hope that we can see consistent compliance and requirements by the land trust. It's going to be a major shift, because if we can go from the abuse of executive directors or employees of the land trust literally taking on the table, literally, without shame, thinking that they somehow are entitled to whatever is on the table and putting themselves first before those that are the legitimate intended recipients of this land, that is really disturbing. And somehow we're going to miraculously change and ensure that there's compliance and that the laws being followed and that the requirements and the rules and regulations are going to be implemented and that we're going to see enforcement. It should have been there from day one, but we can't undo the damage. Hopefully, we can move forward with correction. I'm hoping that this will do so. But again, I think, Madam Speaker, there's going to be a need of oversight to make sure that there's consistent implementation and that those that have violated the law are not rewarded. I think that's what's been most disturbing, particularly in our government. You violate the law and you get rewarded. Somehow that's pretty backwards. I don't think most rational people, good law-abiding citizens in our community find that acceptable. So I appreciate both of you in providing a response. And to Ms. Toulouse, it's tough to speak up. Trust me, you get harassed, you get ostracized, you just get that Atan Baba look, because how dare you? But at the same time, there's a lot of people that expect. They might be quiet, but they expect the right thing to happen. So I appreciate all your efforts for stepping forth in spite of the harassment and all the other things you've had to deal with to speak up. More of our people need to do that. It's not popular, it's not culturally sometimes accepted, but you know what? Doing the right thing should never be anything we shy away from. We need more of our people in this community to do that. If we did, I think we'd have a better quality of life for all of us.
Just please make a note, it was not just CLTC employees. At the time CLTC was under the Department of Land Management, it was their employees that were in charge of the CLT division. And during my time, that's when I started. We were under DLM, and it was DLM, land administrator, and the land agent supervisor, all DLM employees that instructed us this way. And any questions that we brought up that was contrary, I had questions, and I was told, that's how it is, shut up and do your work.
Well, be that the case, and yes, there was a period of time Department of Land Management had oversight over Chamorro Land Trust, but I hope any information you have with regards to any of this abusive or illegal activity that you provide that to the appropriate authorities. I'm sure you have a lot of insight having been there. It's just wrong. We should not use our public positions of responsibility to which we have been granted to use and abuse that power against our people. That's not why we were put here. And unless there is a realization that there are going to be consequences to it, we're going to continue to see it. I'm dumbfounded by it. I'm dumbfounded by it. This is not what we teach our children. This is not culturally even, and most of my orientation is right here, my Chamorro family. This was not the orientation I was raised with, so I am totally dumbfounded by the level of abuse that has occurred here in the land trust. But with that, thank you very much for the opportunity. Thank you for being here and providing your response and your insight. Thank you. I guess I'm the chair again, so I will defer to Senator Luhan for any questions or comments he may have.
Thank you very much, Madam Chair, and thank you very much, panel, for being here this afternoon as well. And I'm glad that at least there's a bill to help correct at least a couple categories, because there are definitely a lot of categories, I mean, outside of this. And I've been working actually closely with Mr. Cruz. I've shared this with my colleagues here as well. And I can add to, I know the previous speaker had said she was dumbfounded, but I'll add to another category of dumbfoundedness to this whole situation. Currently dealing with a situation here, and gosh, I think going on a year now with Mr. Cruz, where supposedly a family was given some land trust property. And they were given authorization for utilities, water, power. And the utility agencies would not connect their water and power where some previous or other authorizations that were granted. So we didn't know the situation here. So I spoke to Mr. Cruz and asked him to meet with myself and as well as the family about this authorization. And because the utility agencies were asking for the deed for these properties. Well, Mr. Cruz dove into the situation because there was lot numbers given. And what we had found out was this property that this family was told to build on was never returned, and they built their home still in federal property. And so this bill doesn't correct it. No bill will correct that. And so these were in the past. I don't know how to correct this. I don't know how, do we move these people out? Do we evict them? We can't evict them. They're not our property. They're still in federal property. They built a home. And when Mr. Cruz asked them, well, how, because they had paperwork, but CHAMORU Land Trust doesn't have paperwork. Well, how was it given to you? We were taken out, and I don't think it's, as ma'am said, it wasn't CHAMORU Land Trust, it's previous to that. They were taken out to the property and said, build your house here, build it here. And they did. So I don't know what the remedy for that is. I was asking Mr. Cruz now, when they're taken out, are they able to jump to the front of the line because of that? It was a government, it was a government ill at this point. I don't know. We don't know. We don't know what the remedy to that is, because they were told to build on this property, which they assumed was Guam property, but when they looked it up, it was still within properties that weren't given back to the government of Guam. The positive thing about that is that we found out that these federal property, at least this federal property site, the federal government has yet to have any plans for development in that area. There's nothing at this point. But, and this family, they're not the only ones. There's some that were built their homes right on the line of deviation between what was given back to Guam and what is still federal government. And so we appealed to even the governor's office to intervene, and the only thing we could do is request the federal government to give that property back. I don't know what the remedy will be for folks who were in that position, who built their homes already, and they were directed by previous folks, which is now CHAMORU Land Trust, but they were called something else or under a different agency at that time. What is, General, do you have an idea of what the remedy may be for something like that?
Well, you know, Senator, you raised a lot of different issues there. The federal nature of it shows that obviously we don't have jurisdiction over the federal properties. The equitable nature of it, maybe a government claim would be filed against the CHAMORU Land Trust Commission. The commission with the AG's office and probably with the governor would sign off on the government claim, would give them another property to be able to use properly, assuming that everything was legitimate in terms of their application process.
Sure.
So I see some non-court type of remedies possible, but you know, it's one of those, the administrator should never have signed off on land that wasn't the government of Guam's property. So you know, you've got the problem.
And there's no paperwork to be found.
Yeah, luckily, hopefully it's not a concrete structure, but I mean, it seems like that person should be made whole by getting an actual CLTC property. So, yeah, there's a lot of problems that are rising out of CLTC properties. As Deputy Miller pointed out, every land has its own history and story behind it. And unfortunately, there's a lot of bad stories that are associated with the administration of this trust right now.
Yeah, this is one of a couple, and the other two have their own history as well, and they're all very different.
Yeah, and the amount of time it requires the CLTC to have to, at least the current administration, having to filter out this, condense it for us to understand decades of history.
Sure.
Is what we're dealing with right now.
Yeah. And again, I'm glad that we're given, again, there's a bill to correct at least a couple of the categories, but yeah, holistically, because it's, yeah, it's a mess. It's a big mess, and and maybe an oversight as to really holistically how do we approach this, and
a report. The committee may wish to ask the CLTC to give you a report. It seems to, the numbers warrant some sort of a report from the CLTC, maybe to give their current view with all the data they've collected to date to help the legislature.
Yeah, and I know also, Mr. Cruz, you said that at this point the CLTC does not have anything to say about the bill, but has the commission members be given a copy of this to review?
Yes, we have shared copies with the commission members, but definitely after it's discussed at our September board meeting, we'll prepare their response and submit it to the Speaker's office.
Okay. Do you guys have a problem making quorum? No.
We have enough members to make quorum.
Okay.
We had a meeting last month, so we're okay.
Okay. Okay. Great. Thank you, Madam Chair.
Just want to say Senator Luhan. Senator Perez. I'm sorry, Senator Barnett. Forgive me.
Just want to say, Madam Chair, thank you, Attorney General Moylan and Attorney Miller, as well as Mr. Cruz. And Ms. Talou, thank you for being here. And please stop it some more. Please continue to blow that whistle, because you have a lot of fans in the public and here in the legislature. I was just reviewing some of the reporting I did relative to this Barragata Heights scandal. It was, I believe, the Pacific Daily News, Steve Limtiaco and I who kind of blew this scandal wide open. And I just think it's interesting that we're here, how many years later, still talking about these 102 leases. And you're right, ma'am, it's not specific to Barragata Heights, but there was a lot of action and activity in Barragata Heights. And I recall a land surveyor with land management getting a lot up there, and then the individual's daughter getting a lot like right next door. And then you had even a former senator who had received the application from her mother, who was still alive at the time, and then the senator, Senator Lee, had requested an opinion from Attorney General Barrett Anderson, and we all know what that opinion basically said was it's null and void. So I'm just not sure, and I would like to ask for clarity. I don't know who can provide it. Where are we with these leases specific to Barragata Heights? If they've been deemed null and void, are we still looking at a situation where you're going to have a land surveyor who obviously had a conflict and may or may not have moved things a certain way to be able to get a property adjacent to his daughter? Or, you know, is this former senator still going to receive this lot? Or what's the status with this?
I believe out of the 102, 16 were supposedly adjudicated.
What does that mean, supposedly?
I guess it was their way of saying, okay, we fixed it. Although I do feel that those files that were adjudicated still need to be reviewed. The adjudication process that was taken may have not complied with our rules and regs. But out of the 102, 16 were adjudicated by the board. But like I mentioned, I personally feel we will re-review that process that was taken. Aside from that, no other lease that was deemed null and void has been adjudicated. They're still in that null and void category, but the board did not adopt the opinion in its entirety.
So does that mean that there's been forward traction with anybody who might have leases in that property? Meaning, you know, it's been determined to be null and void, but they're still clearing, grading, going through the motions of building a residence or anything, or has that activity stopped?
I can speak from since the time I've been appointed the acting director, and maybe a few months prior to, I did oversee the QC process of issuing utility authorizations and things of that for the lessee to further improve on the property. I can assure you that we didn't let that go through, for one, to prevent any further liability on the commission, and two, because the null and void category has not been resolved yet.
Okay. And so in your opinion, will this bill that we're discussing resolve those null and void leases to include the ones tied to Barragata Heights?
I believe in its current form, it will. Although if, as mentioned about the criminal liability, it may not. And if the board should want to add more or recommend amendments to the current bill, it may not. And like Senator Luhan had mentioned about a constituent who's on federal property, but Attorney General Moylan mentioned about a government claim. We have also, if I'm not mistaken, leases that were awarded by CLTC on Guam ancestral lands property. I believe also we have about a couple maybe on private property that have not been resolved either. So those issues, those categories of leases on ancestral and private property, this bill will not resolve it, although Attorney General Moylan did mention about a government claim and issuing them other CLTC property.
Thank you. Mrs. Toulouse, you had mentioned, oh, go ahead, did you have a comment?
Yes, when you talk about the adjudication of the 102 null and void, I can speak on two cases that were on the null and void. And I personally reviewed those files, took those to the board, only to find out the original applicant and the new applicant, how the lease was transferred or the application rights was within accordance to the law. So what it was the child of a sibling, which is allowed to be transferred. So the application rights were transferred correctly. That was the case in both of them. It was the way the applicant submitted their request to take over, how they worded it. So we had to go through the supporting documents to find the family connection and break it down. And when we were able to see how it did fulfill the conditions that would allow the transfer of the application rights to be legally done. The board approved the transfer of application rights. Therefore, the lease could have been considered a valid lease, other than it being issued outside of date and time. But when I was reviewing that, that was when I couldn't understand why some leases were ratified and those same conditions were there. And that is when I started looking into these ratified leases and discovered the amount of corruption and the connection within the agency and how that was done.
Thank you, ma'am. Yeah, that's basically how the story was busted open, is when I think a FOIA was sent and we started reviewing these documents. It was like, hey, wait a minute, that's the last name. And then you started to see connections, right, which were later verified by staff at the land trust. So you had mentioned on the record here that it wasn't just Barragata Heights. There were other areas where this type of activity was ongoing. Could you please share with us that information?
I believe areas in Mingilao, it was done. Atacao area, that was done. A lease was issued on the transfer of application rights. So I believe there was one down on Dedido that was done. There was, yeah, it's throughout the island. And the only reason I know this, because at one point I was in charge of reviewing the null and void cases. And Joey Cruz and I had actually worked on a standard operating procedure on how to resolve these null and void cases. And we were trying to put everything within the act into effect and how we could, you know, how we could come up with the reasons why we would either, you know, vote that the lease be approved or vote for a termination. However, when it went before the commissioners at the time, legal counsel at the time once again threw in, let's ask the legislature to do a law to fix this, which once again, I do not understand. When it was a blatant breaking of the rules and regulations, why do we keep coming back to the legislature? You already gave us the rules. We know the rules. But CLTC made a choice not to follow the rules. For its employees members, family, friends, whatever. It got the special DLM CLTC touch.
Ma'am, of the 2,900 plus leases that have been ratified, do you have any like ballpark figure based on your estimation? How many of those involve some type of alleged corruption?
You know, one of the things that I've been tasked with doing is we're working on the 1995 ones, reviewing them, getting them to see. And so Joey had said that we need to be concerned with the leases that were issued in between the people who are waiting to be issued a lease. So I've reviewed those. So I've probably done about 10 of those. In reviewing 10 of those, half of them don't even have supporting documents to qualify for their initial lease. And it was blatantly stated in the file, because in a file, when you open it up, there's a status information sheet that says client came in, updated information, database has been updated, client called requesting so-and-so return the call. Stuff like that, it's all put in there. It is stated in there, pending supporting documents, pending birth certificates of parents, and yet it was never received, but they still issued a lease. So just based on the 10 that I've reviewed, 5 already have issues.
Ma'am, can I ask, of those 5, how many of them do you think could have been, and I mean, there's a lot of guesswork maybe in this answer, could have been, oh, bring your birth certificate back later, don't worry, we'll issue it, versus, you know, hey, pari.
You know what, the way CLTC was operating, it was basically, okay, if you bring in your supporting documents now, we'll go ahead and accept it, because it's not your fault. That's how we're operating. And if we want to continue to operate that, that's fine. But my concern is for those who blatantly did not qualify.
yeah, I think we share the same concern, and I wouldn't want to see anybody who willingly circumvented or bent the rules or, you know, I mean, even that third degree of consanguinity, and I was attending a lot of the meetings when this was being discussed, I don't think that those parameters really deal with a lot of the conflicts of interest that we have culturally on our island. Because I have no blood relation to my pari, I have no blood relation to my mali, I have no blood relation to someone that I might have been, you know, puckside with, right? And so I think there is a lot of gray area. Not everyone is going to be as forthcoming as you and say, yes, I'm not related to this person, but there is absolutely a conflict. So yeah, I just question that. But ma'am, I have to ask, because you have provided a lot of public testimony on just about every bill that's dealt with the Chamorro Land Trust, and I'm not sure even maybe the Ancestral Lands Commission, and
No, I've never done anything
okay,
for
okay.
ancestral lands.
So yes, and you were, you know, the report that you said was misrepresented was widely covered in the media, and you know, I've read a lot of your testimony, but as a whistleblower and someone who comes forward, have you experienced at all any targeted harassment or any, you know, treatment that you think is related to your willingness to speak the truth to the people of Guam?
Okay, so I do remember after that initial board meeting, and you had Speaker Terlaje on your radio show, and you had brought up, you were concerned that when my PE came, it might affect my PE, and the speaker had expressed the same concern. I can honestly say at that time, no, it wasn't. It wasn't brought up. However, there are times when I do feel I may have not gotten the promotion because of whatever I said. But then it also could have been, I did terrible at my interview. So either way, it's when it comes to issues like that, it might be my personal feeling, but how somebody dictates my answer at an interview could sway whether or not I got a position or not. Despite I may think I'm the greatest person, but the interview said this person is just, do not give her this job. Even though in my mind, I'm thinking I'm absolutely fabulous, but you know, that's in my mind, because in my mind, I'm 105 pounds and I'm 5'10", which apparently my driver's license begged to differ, so, you know, in my mind's eye, that's how I see myself. The reality is a totally different story.
Thank you, ma'am. And I guess my last question is for Attorney General Moylan. You know, a lot has been said on the record here today, and there's even more that has been covered substantially throughout the media relative to Barragata Heights and 102 leases. So I guess my question is, are any of these pieces of information that we've gathered on the record going to be used by your office to conduct any further investigation into these leases and these properties? And then the follow-up would be, in this proposed bill, Section 3, there includes a no waiver of criminal liability, which reads, issuance of a new lease pursuant to this section does not constitute a waiver of any criminal liability associated with the issuance of an original lease.
Right, I'm the one that incorporated that to the draft when it was in our office, and Deputy Miller had been communicating with the CLTC staff. Obviously, Senator, this reeks of allegations of corruption, government corruption. Statute of limitations doesn't start to run for government officials until they leave, but you're talking 30 years of potential criminal liability going on. You're talking about memories. You're also talking about statute of limitations for those people that aren't part of the government, which for the most part for felonies is 3 years. So, you know, like when I came into the office, the clock is always ticking. So all the different struggles that we all have to deal with in the government are insurmountable. And that's why I wanted to focus upon the civil relief, get the system working again. It sounds like my deputy tells me that there's good people there, and I can tell from Lydia that she is very publicly conscious. First time I've met her. That's the type of people that I will have Mr. Deputy Miller speak with to ensure the validity of the information that I'm getting so that we don't waste our time here before you. So I've already asked him if he can obtain a report for me so that we can get these numbers, because the numbers, like Senator Brown mentioned, they're overwhelming. You know, for all the work that's been done and all the good intentions that were meant since the 1990s. To see numbers like this is bad. And for Senator or General Anderson to have issued that letter the way she did, that they're void, at the minimum, it's an opportunity to issue new leases, having cleansed out a lot of these the bad faith, or whatever you want to call it, that was going on, fraud, bad faith. It all reeks of impropriety. How do we get the system back calibrated online to what was the original intent? And that's been Deputy Miller and our concern at the AG's office, to try to get it back on track.
Thank you, AG. And I just, I guess, on behalf of Ms. Lydia, and I agree with you, I don't want to see anyone get away with any bad faith acting or fraud or any other type of alleged corruption, especially with something so sacred as the CHAMORU Land Trust, which, as we all know, is it's a restorative justice for, the land takings that our people endured many years ago. So thank you, AG. Thank you, Mrs. Toulouse. Thank you, Mr. Cruz. Sidos Masi, Madam Speaker.
Sidos Masi, Senator Barnett. Senator Perez.
Thank you, Madam Speaker, and thank you to everyone here that have testified. Thank you, Lydia, for being so diligent regarding the rules and regulations. So in looking at this bill, I'm just thinking that a lot of this can be handled under the current rules and regulations, except for, perhaps subsection B2. So again, I guess I'm waiting for the CHAMORU Land Trust's testimony to see where they're going to weigh in on this bill. But my concern with B2, which is, so what the bill states is that if, subsection A states that if there's no finding of, that it's contrary to the rules and regs, then they can basically approve it, right, if I'm reading that correctly. And if they're eligible, so basically they're following the rules and regs. But if the lease is found to be in contrary to the rules and regs, there is an exception possibly made, which is that they have, are in compliance with the terms. There may be some requirements or conditions required of them. And there's a third category where they are, the lease was made in contrary to regulations and they're not in compliance. So I guess the real question for me is, so in order to clean up the sins of the past, if this bill is passed, I mean, are there going to be a really rigorous procedures in place to really find out those that that were acting in bad faith, right? So we know about relations, but like Ms. Lydia said, there's potential collusion or collusion that's happening that's not necessarily related by blood. And so how does one really assure that we're not letting people get by when these situations are very hard to really adjudicate, right? I think that's one of the issues. If nobody's going to stand up and say, okay, this person did this, or they, it's hearsay, right? So how do you really ensure? I mean, to me, it's important that we abide by these regulations and to have statements that may not be, the proof may not be strong enough. And that's my concern about this section, particular section. So I'm just stating that. I like timelines. I think timelines are important. I think that's something that really needs to happen. So I know in 2016, that's when the initial null and void decision was made, only to find out later there's even more problems with some of these leases. And I think it's really important to really, kind of, without this bill being passed yet, I think it's important to have timelines to ensure that, leases are being properly done at this point. So what is the status as far as leases? Are these the only leases that are yet to be cleared, or there's other leases waiting or applicants waiting?
The 2,911 number is what leases we have in total as of today. There's over 8,000, maybe 9,000 applicants that are pending a lease award. This much I can assure you is that we have a process now for the upcoming leases that will be issued soon, or we'll be notifying the next in lines shortly. We've created an internal checklist. So we have the review and the qualification process, we have the land inventory process, and then we have the lease execution process. Now, within the checklist, each process will check mark whether it's completed. And when it reaches the next process and if a check mark is missing, then it's kicked back. So that's our internal quality control process to ensure that we're following the rules and regs and the act in terms of any lease awards. Now, in terms of, a while ago, the board had decided that disclosure of any conflict of interest would be up to the third consanguinity of relation. We're going to request that it extends, and even through affiliation, whether it's not by blood, if it's, like Senator Barnett said, a pari, any type of affiliation should be disclosed. But we'll present that to the board for their approval. Now, like Lydia had mentioned, after the Barragata Heights debacle, there was a consanguinity form that was created. Unfortunately, sometimes when that form was completed, it was filed away without any further action from the supervisor, the acting supervisor, or the director. Today, we ensure that if there's any disclosure of any type of relation, that the document is completely filled and there's instructions on who should be processing and who shouldn't have any hands on it. So that much I can assure you as of today.
Senator, if I could make a point here on the topic of timelines. From my perspective, perhaps the most important language in the bill is at page 4, lines 3, 4, 5, 6, 7, subsection F, which frankly directs the commission where, people have been given an opportunity to remediate their problems, whatever those problems may turn out to be, however you all choose to craft the remediation process, but they don't remediate the problem, then the bill unequivocally directs the commission to seek to move those people out. And as the person who sits with the commission in their committee meetings, commission meetings every month, I am absolutely certain that the first time we try and move somebody out of a property, we will hear a tale of woe about how all kinds of bad things are about to befall this otherwise wonderful lessee and their family. And as somebody who sat on commissions before, especially volunteer members of commissions, tales of woe are often persuasive. And they motivate you to give that person the benefit of the doubt. Give them another month to try and find the paperwork. Give them another 90 days to try and come into compliance. And at some level, that is part of the story as to why we are here today. I think what the commission is very hopeful is that they will get some clear direction from the legislature as to people get a certain amount of time to try and remediate these issues, and when that time expires, it is the legislature's preference to move forward and try and move these people off the property, notwithstanding the inevitable tale of woe.
Okay, thank you for the responses. Yeah, I was thinking so basically with these 2,800 leases, that doesn't impact the applicants that are waiting? Does it affect them, the other applicants?
No, I don't think so. That's the intention of the bill.
Okay. Okay, I'm going to continue to wait and hear more testimony. I see some of the board members have showed, so thank you. Thank you, Madam Speaker.
Senator Perez. All right. Commissioner Herrera, would you like to present testimony? If I could ask the rest of you to stay, if you have a few more minutes, please.
Good afternoon, Madam Speaker. My name is David Babauta Herrera, and I am a commission member with the CHAMORU Land Trust since February of 2022. So I am here to testify in favor of bill number 334-37, and which is generally, an act to remove the legal clause on the existing leases issued by the CHAMORU Land Trust Commission. I want to thank the staff and management of the CHAMORU Land Trust for all their hard efforts since back in 1995. Long story short, since 1950, under this roof is where the Organic Act started, and under this roof is where Senator Paul Budauzu came in and decided that from all the land condemnation done by the naval government between 1898 to 1968, that there should be a remedy for those families that have had their lands entirely condemned or partly condemned or not condemned at all. So that's Public Law 12-226 now. We know now that today there's about 10,000 applicants, 2,900 leases, and we're saying there's so many discombobulated contracts that have been going openly or discreetly. Now, where did the problem start? Under this roof, when 12-226 was implemented and, in 1974, and in 1975, Governor Berdalio signed the Public Law 12-226. CHAMORU Land Trust became IDO up until the time when they did the Arrendo program. The Arrendo program is the land use permit. It was 1952 when they first issued the Arrendo program. What was the Arrendo program? It's a Spanish word for leasing of the land. And at that time, they had a Category 1, Category 2, and a Category 3. Cat 1 are for applicants that have had all their lands condemned. These are families that had properties in Sumay, FENA, NAS, NCS, Naval Hospital, NICTANS, all the way up to Anderson. So these families were issued a land use permit based on Cat 1, Cat 2 for those that have had partial of their properties condemned. Cat 3 are just the families, local families that want to farm or live on the land. Now, why am I saying that the problem started under this roof? Because under this roof, it was the members that understood the laws of the land, the laws that were made by the First Congress, the Second, the Third, the Fourth, Fifth, up until the 37 Guam legislature. Why am I saying the 37 Guam legislature? That part of the problem is in the legislature. Part of the problem was back in 12-226, which is back in 75. So during that time, the CHAMORU Land Trust was put at idle. So when it was put at idle, it was put on the back burner. Some genius group created the Land for the Land Lease. Land for the Land Lease program was for people that have had no land, would have the first crack in getting a quarter acre for $2,500. So they started the subdivision up in Jigu, Dedidu, Haga, Dumatak, Malesu, up to Talfofu and Manilao. Imagine a quarter acre lot worth maybe 75, 100,000 at $2,500. But the disparity at that time, right, is that we have to ask how can this legislature at that time create the Land for the Land Lease and totally forgot about the people that had their entire property condemned on the lots that I just mentioned, from Fenna, Sumay, all the way up to Anderson. That's an injustice, in my opinion. Now, what happened during that time in 95, 92, 93, 94, 95 was that the lawyers at that time were saying that the CHAMORU Land Trust is a race-based program. So it went to court, and you were part of that defense group, Madam Speaker, in 97, 98, or 2000, when it went to the U.S. District Court, and it was adjudicated that the CHAMORU Land Trust program is not a race-based program, it's a land reclamation program for those people that have had all their properties condemned. This has nothing to do with race. Oh, the Koreans, the Chinese, the Japanese, the Anglo families that we have in Guam were qualified if you had your property condemned by the federal government or the local government between 1898 to 1968. So now fast forward to today, we did the protest, we repealed the Land for the Land Lease program, all the balance inventory on about maybe, I'm saying maybe about 4,000 lots. The remainder were transferred back to the CHAMORU Land Trust under the land management umbrella. So now the question is that we have 2,900 leases. We have this amount of problems that we have today. And fortunately, it's good that we have the attorneys here today that recommended that these are some of the remedies to fix the problem since the since the issuance of the first lease back in '95. So fast forward to today. Where did the problem begin? So when the CHAMORU Land Trust was implemented, I can honestly say, and this is a public record, that I did join the CHAMORU Land Trust Commission under Director Joseph Borja, and one of my assignment was to go up to lot 7161-R1 and inform the families there to vacate because they are going to start the raceway program. That's why I'm saying the problem started here. The CHAMORU Land Trust has no business in racing. The CHAMORU Land Trust has no business in playing golf or subsidizing golf. The CHAMORU Land Trust program is to provide the lands to people that have had their properties condemned. So, again, remember, I just mentioned that under this roof, the Land for the Land Lease was conceived, passed, and implemented. Then we had to fight to have it repealed. Then one of the first jobs I had, and Joey can attest to this, we were working together at that time, and I refused to go up and do any eviction to the families that are there. Of course, it was Senator Caspar Bauer that had the great idea to do, or somehow that group selected 252 acres, 100 million square meter on lot 7161-R1. So my question at that time is that, what's wrong with the Cross Island racetrack? If it was profitable, smoking wheels was smoking, why would you want to move that amount of activity from the Cross Island if it was such a lucrative, prosperous kind of operation, and move it up north on a untouched area where people are farming? So again, I refused to go in and do that eviction. It went through. They started the project, and today, as of the 29th of August, during your session, when you guys hit the gavel to pass the public law by the 8 apostles that now said that the 250 acres are to be occupied by one group. That's a sole source group for one group, directing the Chamorro Land Trust to entertain that group within 90 days. Is the 90-day clock on now? I don't know. If the ADLUP is going to sign it, make it lapse into law, or repeal or reject the program. So these 8 apostles, right, again, under this roof, under the legislative body now, they want to become part of the executive branch. So we're waiting for this group to come in on our first meeting on the 19th. Is that our meeting for August, right? September. So I hear a lot of word here about the board can do this, the board can do that, the board can decide this. But the 8 apostles already decided that we are to entertain this sole source. So we said, okay, if that's the law, then we'll do that. So why am I making this a parallel between 1950, 1952 with the Arrendu, then the land for the land lease program, then the Chamorro Land Trust, and then now we're back at the raceway. Who makes the law, right? So it's under this roof again, and then the executive branch is supposed to implement the law. But part of the problem also is in the executive branch up at ADLUP, or if the governor's office was right across the street at the Palazzo, it's the people on top or the person on top that directs the cabinet what to do. So, how many of these 2,900 leases that have been ratified? And what I hear is that we were stuck at number 6. I got on board on about February or March of 2022, and I did an analysis. After working about 2 years with the Land Trust, I extracted, went to the Department of Defense, came back, and I joined the commission in 2022. So that 30-year time frame, when I came on board, Mr. Joey Cruz, that was just a messenger at that time, was the acting director. And I said, oh, great. So we have a walking historian in the house. You have directors that come in for 1 month, 1 year, 2 years. When I got on board in 2022, there were 4 directors that were there, from Hattic all the way to Birch. Every year you have a different director. So inconsistent, but Joey was always there. Not a problem. So I asked Joey, what's the problem? Why are we stuck at number 6? And when we protested back then in '95, we were going to use the hangar up in the airport to do the first come, first serve. When we did the analysis, right, there was only about maybe 60 of the Chamorro Nation group. Parin Ron Laguana was part of that. There was only 60 of us, but we projected that when we pull the string on this dynamite, right, it's going to create maybe 5,000, maybe 10,000, plus or minus. So we'll say, we were betting that we'll just use 50%, there's going to be 5,000 that will come out. So we did another analysis, and we say, you know, if we're going to use the hangar, we're not going to have enough space. Why did we project that? We projected that assessment because when we had the public hearing for the Chamorro Land Trust, and I'm pretty sure Senator Joanne Brown was there at that time, we couldn't fit the amount of people down the street. So we had the public hearing down at ADLUP. You may recall that, and it was a 2-day, 3-day continuous public hearing. And if I'm not mistaken, we had about maybe 400 or 500 people that came in to testify. So just based on that analysis, we're saying this thing's going to take off. And we did. When we decided that we're going to do venues in the north, central, south, and it started on Saturday. We went around and we scouted the area, and from 12 midnight, people were standing in line. Long story short, today we have 10,000 applicants. We had 2,900 leases, and now most of them have a problem. You said there was only 19, or how many were in good standings of the 2009? 19. That's not surprising, because when you have Adelup telling the cabinet, I want this pack of people, I want properties for these guys, land agent Joey, land agent Dave, find the lots. That's just one problem. The other problem is that the properties at that time, we only had so much properties that was left over from the Land for the Land Lease program, so we had to do some survey, real quick, fast survey. We had to locate properties from north, central, and south, get a surveyor in, not land management, contract a surveyor, do the subdivision. Today, you may hear a lot of the problems that a lot of the people that were given properties up in the north with only a quarter acre is in violation of the half-acre requirement on top of the aquifer. Senator Joanne Brown here can attest to that. You need a half an acre if you're on top of the aquifer. But at that time, the quarter acre lot was very popular. In fact, over at the Swamp Road, Joey, the size is about 500 square meter. 1022, track 1022, about 500 square meters, still in violation of the half-acre requirement. But the projection at that time is that we envision, get the survey done, start getting the infrastructure in, and cross your finger that it's gonna sink in, and by the time the infrastructures are coming in, the lessees were occupying the property, and you have a development program. But we miss one more link. It's the vertical, which is the housing. Can these people build the homes? Maybe yes, maybe no, depending on your income. And today, we already know that even if you give a family that earns 50 grand a year or 100 grand a year to construct a home at $200 a square foot, that $100,000 income that you have, you're gonna be barely making it. Property's $1, you build a 3-bedroom home at $300K, you pay a mortgage at $1,500 to $2,500, and you fall under the poverty level category. So, long story short, Madam Speaker, thank you for Bill 288. So we found some funding source. Kind of emotional, right? But all along, we had a funding source that was available. We just didn't know how to mesh it together, but today, with Bill 288 now being a public law, I think 137-114, you can do the fact check for those that are listening that's going to be attacking what we're saying today. And we say good luck. But we're gonna reach that point that we're gonna have a proper subdivision, proper infrastructure, and affordable homes. Do we know that that's gonna work? Yes, it's gonna work. Because the private industry have been using this program. It's a tax rebate program with the Internal Revenue Service, with the U.S. Department of Agriculture, and many more programs. But it's going to work. The vision from Senator Popo Donzo back then may have envisioned this kind of program to fix those problems of the land condemnation back then. So this is a lesson learned for us for the past 30 years, at least for myself, that we were always more or less expecting the local government to provide the water, power, sewer, homes, for your water bill, your food stamps and stuff. But, we're only 74 years old. From the Organic Act, the United States is about 270 years old. So am I optimistic that this program is going to work? No doubt. At least that's what I feel. Because folks, there's billions of dollars pouring into Guam. We know it, you know it. At the time the bubble was here during the Japanese love affair with the hotels, well, that bubble burst. Now we have a love affair with the Department of Defense. And they're here to stay because they want to protect the motherland called the United States of America and our neighboring Chinese bloodline, because we're basically Asian Pacific Islanders. They're not in a very good relationship as we speak. So that's why we have a lot of radars and missiles up at Barrigada Heights. And so, you know, it's a World War III in preparation all over again. So put your seatbelts on, build the caves for atomic attack. Like Senator John Brown said, where's the fallout shelter? Well, Department of Defense, because we know that you're listening for every word that we say, the Central Intelligence Group. So build us those caves because we know that it's going to be a rough 100 years from now. Now it's 2024. By the year 2124, we hope to be still around. So that's it, Madam Chair. That's to resolve the issues here. Again, I thank Mr. Miller ever since he came on board. He can attest to General Doug Moylan that we have been asking a lot of questions. And I want to thank the General for assigning Mr. Attorney Lee Miller to our side, because he can attest that we ask him parallel and serious questions. And I'm glad that he's open to us, that he answers a lot of the questions that we have. But I just want to thank everybody in general. So that's it, Madam Chair. Thank you again for your support, and I thank the group, the 37th, for their support to the Guam legislature. To the CHAMORU Land Trust group, and the 10,000 members that are watching. I know, you know, the Raceway group came in here. They're very loud, but folks don't. The 10,000 applicants, man, are listening, and what's that? You know, we're bringing positive development our way for the constituents. Thank you, Madam Chair.
Senor. And thank you for also your service on the commission for these many years, and prior to that as an employee, I guess. And for, of course, your advocacy with the Nacion Chamorro to actually get this implemented after many, many, many years. We owe you a lot, so thank you. Do you have any objection to the philosophy of, like, forgiving through this bill? We're going to forgive those that made errors, or the errors that were made by anybody, and proceed and try to give them leases and compel them to comply from here on, or comply within a year and then from then on?
Thank you, Madam Speaker. That's a complicated question, because the way the bill was languaged, and we're very familiar with some of the options of how to correct the issues, because we have discussed this with Attorney Miller. Based on the language, it's basically putting the responsibility to the commission members. That's what I'm seeing on this language, and I know Attorney Peter Santos was mentioning to maybe assign I'm not sure if it's was that a substitute attorney to watch over this litigation, because it's complicated, because like we mentioned, we found out 223 lessees were on unregistered properties, 223. Now, what do we do with the 223? The alternative resolution here is to register the land. Now, do we have enough attorneys to work on the registration? We may not, but if it's possible, we can give the options to those 223 lessees. If they can hire their own attorney to process the registration process, that may be one option to lighten the load under General Moylan's group, and perhaps include the option that when we have the fundings available to compensate the attorney that's going to fast track the registration process for the 223 lessees. Many of these lessees, and Director Joey Cruz can attest to this, many of them have applied under the Veterans Administration Program, under the Guam Housing Corporation. Many of them have built homes on these properties. Some of them have a lot of small business administration loans that were approved from back then, from the last 20 years, from different typhoons, other than Mawar. What Typhoon Mawar did is that when we got on board and families were coming in for a loan guarantee, that's when a lot of these issues were discovered, when the land agents would go through the file and discover a lot of non-compliant issues. So the question is, am I in agreement to kind of do an act of contrition and waive and forgive the sins of the past? I really have to analyze. We have to weigh this out, because how do we provide justice for those that lined up and followed the law, and how do we give fair justice for those that have shortcutted the system, and maybe not entirely in their own decision, but as I mentioned, when I was there in '98, we would be given an assignment of about 10, 20, 30 voters from Adelup, and they'll give us the instruction, 5 properties for this group. That's your political payback. Now, again, I rejected to evict those people from the raceway where they did the raceway, and today, now it's biting us from the back. That's the problem. So my opinion on this one is that, yeah, we need a legal expert to help us on this one. Giving it to the commission, I have no legal background, and a lot of these issues are based on laws that are in Chapter 75 Alpha and Public Law 12-226, Public Law 37-112, which is the when it changed from to the land condemnation process. So I will have to really sit down and analyze, because see, 2,900 and you only have about, well, you have about 90% that's non-compliant. That's a lot of load to compare to the 10,000 applicants that are waiting in line, or 8,000, I believe, but we have more qualified applicants that are coming in, because back in 1995, we estimated 8,000. You multiply that now with our age group, you may have already the children, and the children, the first generation of children at that time may have the second generation now, so that 8,000 may be multiplied 3 times, so about maybe 16 to 20,000 that are waiting. How do we give them fair justice when this 29 or 90% of the 29 violated or is in non-compliance to the rules and regulations of the law that was established by law?
Well, if we pass this bill, then the way you're going to have to do that is by moving as fast as you possibly can to address those 8,000 that are waiting, because, especially because you took care of the 2,900 that didn't necessarily wait. You really need to move as fast as you can on the rest. You have to be ready with all of those things. We have to have our land registered so we can dole those out as fast as possible in leases. And we have to have the people on the list processed, right? And I know you're working on all of these things at the same time, but that's what we really need to do. And maybe that's, well, we need that to be really put down, I think, in writing, how we do this all at the same time. That's the only way to honor them, I think, those that really lined up and waited for that long. Attorney General, may I ask, so the bill contemplates if they need a registration, right? Then that the CLTC, of course, is the landowner, they need to go forward with the registration. And in the meantime, we hold on to their leases, or we don't issue one until the land registration is complete, if that's the case.
Madam Chairman, I'm happy to report that the Attorney General's office and the Commission staff have already started the research to where we have the maps and the signed off by the surveyors, and we are fully aware of the lack of registration issue, and we are already at work getting those properties into court and applying for the registration.
Okay, that's great. Again, so understanding, according to you, Attorney General, that this will not ratify inaction due to lack of utilities. We're going to give them a year. If that's their issue, we're giving them a year, and maybe we can hold off if they didn't have a land registration, because we're putting the burden on ourselves to register these properties. But if they don't have utilities, and that's the reason they're not building, we just have to say the property comes as is, and you have to put in your infrastructure within a year?
Madam Chairman, what the bill says is you have a year to meet all the requirements that the Commission has already established in regulation. If for whatever reason that's beyond you, okay, we understand, and then, but give us back that property, and we will move on to the next applicant and move through that list and try and identify folks who are more comfortable living on a lot that doesn't have full municipal utility service.
All right, and then my last question is this. You know, we've heard about, this was reviewed in 2018, then it's being reviewed again recently. We've heard, you know, and then we're going to review it again because of this bill. I really want these people, when they finally get their leases after this bill's passed, that they are not going to be reviewed again. They are not going to be having somebody 10 years or 20 years from now reviewing their documents from today and saying, oh, you didn't comply, now you're void. And can we give them some kind of assurance that way, that those that pass the commission after this scrutiny, right, that if the commission votes on it, that they are valid? Can we do that? Is that, I mean, we're, you know, of course, trusting that the commissioners are going to do their due diligence and that the staff at the CLTC is going to do the same. And can we say it's final at that point?
Madam Chair, members, that's certainly the intent. The way the bill is drafted and kind of the process by which the commission would bring closure to all of these issues is when a particular file, when it was time to issue a lessee a new lease, what the bill contemplates is that the commission would find that this tenant, this lessee, is in full compliance with Chamorro Land Trust law and regulation, and therefore is entitled to this new lease. So it's our view that that finding by the commission of full compliance should resolve the discussion going forward.
All right, well, yeah, thank you, because that's my frustration with the prior findings. Why
Right.
aren't those valid?
Right, it should have been done the correct way the first time. This is the second time. It's up to the commission to have good people like Lydia to make sure it's done correctly. I
All right.
guess.
Well, Mr. Cruz, do you think the time periods in here are too short or too long? Or just right?
I believe the 2 years time frame for us to review is sufficient and to conduct site inspections. Like I mentioned previously, we have a compliance team already, so we've been conducting compliance inspections. We just recently completed the compliance inspections in PD. We'll be moving to another municipality.
All right. So there being no additional testimony, the committee will consider bill number 334-37 as substituted by, this bill, 334? Is that the right? Sorry, hold on.
Of course. Yeah, we got
Yes, bill 334, duly heard. It's now 3:10 p.m. Situs Masi Torres. Thank you.
Madam Speaker.